Conflict resolution expert Dr. Kingsley Makhubela is joining us now to have a look at this development. A very good evening to you. Thank you so much for speaking to us. I mean, there have been various reactions around this, but I think what it comes down to, and just looking at some of the reactions, is that the concern originally had been, particularly when it comes to the head of the executive, the president, was that he gets to judge his own ethics, particularly in terms of how Section 96 of the Constitution demands that members of the cabinet must act in accordance with the Code of Ethics as set out by the national legislation.
So the judgment is a very important evolution in our constitutional democracy. If you recall, the CR17 challenge has been that the funds raised during that time was not falling within the ambit of disclosures required by the ethics, executive ethics. Now, the court has made it quite clear, and as you can see, the unit for contestation of political office starts at the political level, party level, at individuals level. So those kind of contribution ought to be disclosed to allow a proper oversight and to ensure that, as Judge Mogoeng once said, that people are not captured in advance, is to address issues related to corruption. I think this is a big victory for democracy in our country. In other countries, you will recall, countries like the US, the Campaign Finance Act in the US actually made it a criminal offense not to disclose details. If once you fundraise, not to use the money for what it was intended for, you are not allowed. I think in our case, we need to move further and ensure that the funds raised for political campaign are precisely used for that.
What I find surprising, and we'll look back at it step by step, is that the complaints go as far as 2011 when it was first raised by the public protector then. But in an earlier court judgment, the Constitutional Court, the situation between public protector versus President of the Republic of South Africa. So the court then found that breaches by the president should be referred to the National Assembly, since the Constitution already empowers the National Assembly to take action against the president in certain circumstances. And that's because if there's a complaint is raised to the public protector, it then goes to the president. So then that means that the president must make a judgment about a complaint concerning him. How could this not have been foreseen?
Well, I think if you look at the act itself, it was very mum on issues of how to regulate the usage of money within political parties. And the act was intended to allow members of the national executive and provincial executive to disclose their financial interests. Of course, if you are running for a political office, you have an interest in the finances that are raised in your name. And therefore, it's incumbent upon everyone to really disclose that. And if you recall, the previous Constitutional Court judgment, particularly the minority judgment, which was penned by the then Chief Justice, was quite adamant that we should not allow the Ethics Act as it is to continue. And I think the Constitutional Court in its current form has realized that, and that's why they're trying to close this gap, because if you don't close this gap, we are in for a high jump at SABC, because people will go and fundraise and they will never disclose. And you can see, even within this judgment, the concern is around the pervasive nature of corruption in our society. And if we don't close the loophole with respect to this, our democracy is likely to be derailed.
I mean, I want to just look back at what has happened in the past, particularly this thing of disclosing financial interests. The previous public protector, for instance, had said part of those loopholes when she was examining whether then President Jacob Zuma failed to disclose his financial interests in terms of the code, that it created the unusual situation where both the complainant and the presidency were in agreement, at least over the fact that the code was unclear about what should occur if a president has breached it. Now, there were various things that were listed in this, the issue of the amount to whom the president ought to report some of these interests, and there was I think, reasonable expectations of privacy. But when one thinks of a head of state, and as you say, in terms of financial disclosures, whether they benefit as an individual or as a party, one would assume that transparency is somehow ingrained in the law, because one would expect that they would be easily corruptible because they occupy such a high office. So if there are no rules that say this you must declare and to whom and how much, I'm still baffled as to why it's taken us so long.
Sebiso, you recall that even within our parliamentary system, there's no portfolio committee that deals precisely with the presidents. It's only now that they're struggling to find a home to address issues related to the presidents, where you could find a better oversight by the parliamentary committee. So that's where one big challenge is. But you cannot have a situation where the president is the chief executive and the president has enormous powers. As one academic once said, he has the powers of Caesarian nature, that he can decide issues that are having serious impact on us. And if the president is unable to be held to account in terms of who is funding his political campaign, who is funding his political ambition, we're going to have a challenge in a country, because people create proxies to run their campaigns and distance themselves from those proxies, even though they benefit from them. That's why I'm saying, moving forward, it will be very important to look into how the Campaign Finance Act is going to be developed in South Africa and created. And I think we should learn from other countries and take good examples, good systems, checks and balances that exist. I think even the current judgment in its form, it's not enough. It doesn't address the entire Campaign Finance Act and to see to it that there are no abuses of the campaign. I mean, there have been a lot of stories flying around as to how the campaign finance is being abused, judicial patronage, and so on. Is that what it's intended for? So I think the loophole must be closed, and we must find a really tight way to control this flow of capital to politicians. And I always say corruption, it's equals to politics plus money. And that's where you find corruption. Right. Once you put the two, corruption plus money, money plus politics is equal to corruption.
And of course, there have been changes. I think in 2016, there were some changes, but apparently because the president himself never gazetted them, therefore making it permanent, this is also partly where the problem lies. Thank you so much for speaking to us. I wish we had more time to clarify some of the issues. Dr. Kingsley Makhubela, thank you very much.